Hello everyone, I'm Ankit and you're watching StudyIQ IAS English. In today's video, we'll try to understand why is anti-defection law in news currently, and the reason is simple. Yesterday, 7 Rajya Sabha MPs belonging to the Delhi-based Aam Aadmi Party, they have switched their sides to Bharatiya Janata Party. Now, after this, the Aam Aadmi Party is just left with 3 MPs in the Rajya Sabha. So what will happen to these MPs who have defected to BJP? That is what we are going to understand in our today's video. And therefore, understanding the provisions of anti-defection law becomes very important. Now, this topic is very much important from your exam, and as a result, I will ask you all to download the notes which I will be using in our today's session by going to this particular Telegram channel called as ATS Live. And while you're in this channel downloading the notes, also do not forget to subscribe to it. Right? Now, let us try to first understand what is a political defection. Political defection is a scenario when an elected representative, be it an MP or an MLA, switch sides to another political party. Right? Similarly, if you are an independent MP or an MLA, you can't join another political party. That would be called as a defection. Now, why this is a problem in Indian politics? Let me tell you first of all. Now, from 1960 to 70s, there was a time when frequently MPs and MLAs were changing parties, and there was a very funny incident. A Haryana MLA, Mr. Gayalal, he's changed political parties 3 times in just the span of 24 hours. And that is why this defection politics was popularly termed as Ayaram Gayaram politics, and it became a function of the state of political defections in India. So it became necessary to outlaw this thing in order to prevent MPs from getting elected on one party ticket and switching sides to another political party. And as a result, 52nd Amendment of the Indian Constitution was introduced in 1985, where a change was made in the Indian Constitution by introduction of 10th schedule, which ultimately became the Anti-Defection Law. And one change was made to this under 91st Constitutional Amendment Act, which was passed in 2003. So what were the initial provisions, how the changes were made? We are going to cover it, don't worry. The purpose of introduction of anti-defection law was to curb political defections in India and bring a sense of political stability so that these defections can't be engineered in a way to put risk to government in power. Similarly, it will also inculcate party discipline, and most importantly, it would make legislators accountable not just to their parties but also to their electors, because you need to understand, when any person is elected as an MP or an MLA, so only a part of the votes is given on their name. A major chunk of the vote which comes to them is also in the name of their political parties. So they can't betray this trust that the voters have invested in them because they have contested an election based on a particular party's ticket. And this was the reason why you need to bring anti-defection law. So what are the provisions of anti-defection law? First of all, anti-defection law is quite unequivocal. It states that if you commit certain actions, we will disqualify you from being a member of the parliament or a state legislature. So what are these actions? Let us understand this. Now, if you're an MP or an MLA and if you voluntarily resign from the membership of your party, then your membership is liable to be disqualified. Similarly, if you vote in a manner against the decision of your party, or if you abstain from voting against the decision of your party, which is called as a whip, then also you are subjected to be disqualified under anti-defection law. And this is applicable specifically if you're a member of a political party and also an elected representative. Similarly, what about independent members? You need to understand, there are many members in Lok Sabha as well as Legislative Assembly who get elected without having any party allegiance. So is anti-defection law not applicable to them? The answer is no. Anti-defection law is also applicable on them. So if an independent MP or an MLA gets elected into the office of a public representative, and after this election, if they join any political party, then also they are liable to be disqualified. Similarly, if you're a nominated member of Rajya Sabha, you have 6 months amount of period between which you can legally join a political party. Beyond 6 months, if you decide to join a political party, then also your membership is subjected to be disqualified as per the 10th schedule of the Indian Constitution. Clear? So is this a blanket provision applicable to all MPs and MLAs? The answer is again no. What is the exception provided to it? Let us understand this. First exception is provided to the presiding officers of the house. For example, if you're a Lok Sabha speaker, chairman of Rajya Sabha, or speaker to any legislative assembly, you have an option to resign from the membership of a party. Even then, your membership of the house is not subjected to be disqualified, and this is provided in order to ensure that the presiding officers of the house are able to discharge their duties in a impartial manner. But the most important thing that we'll use today is the another exemption of merger provision. This anti-defection law states that if 2/3 members of a party in a particular house, either in Rajya Sabha or Lok Sabha or Legislative Assembly, if they decide to merge with any other political party, then also anti-defection law is not applicable on them. And this is what has happened in case of MPs of Aam Aadmi Party in Rajya Sabha. Rajya Sabha has 10 Aam Aadmi Party MPs. 7 have defected to BJP. So this is 7 out of 10 MPs, which means 70% of the members have agreed to join BJP. And this qualifies this merger threshold, which requires at least 2/3 of members, that is 66.66% of the members. So 70% is more than 66.66%. So it is expected that this would qualify as an exemption, and therefore their membership will not be disqualified from the Rajya Sabha. Okay, now let us try to understand who gets to decide on the matter of disqualification. Now, the trigger for action of their removal must origin from any complaint. So, therefore, a formal complaint needs to be made in order to initiate the proceedings. Who considers this complaint? It is the presiding officer of the house. So, in case of Lok Sabha, it would be the speaker. In case of Rajya Sabha, it would be the chairperson of the house. And in case of Legislative Assembly, it would also be the speaker. Now, speaker just gets to decide on who will be disqualified and not, but he also gets to decide on the rule making power as per the provisions to implement the 10th schedule, right? So, speaker here is the judicial authority, or will be the adjudicating authority, who would decide on the matter whether a particular MP would be disqualified under 10th schedule. Now you need to understand what are the role of political parties here. Political parties, as I told you, they from time to time give directions to their MPs on how to act in the Lok Sabha or in the particular house, and this directive is called as a whip. If you violate this direction of the political party, whip, then your membership is liable to be disqualified as per the anti-defection law. So in what ways does party communicates its decision to its MPs and elected representatives? Let us understand this. Now there are 3 types of whips. First is a one-line whip. One-line whip is basically a lightly enforced directive which is primarily given by a political party in order to notify the members about any session that is going on or any voting that is expected to happen, right? So what the legislators have here is an option. If they do not want to vote in the direction of the political party, after the whip, one-line whip that is, they may choose to abstain from the voting, and parties are not liable to take actions, but only in the case of one-line whip. On the other hand, 2-line and 3-line whips are much more enforcing in nature. 2-line whip, for example, it requires the members to be present in the house during the voting, and if they are not present during the house during the voting, then their membership will be cancelled because they have violated the direction of the party. Similarly, the 3-line whip is the most important whip, which is a strict directive issues in critical manner. So suppose if the government needs to get a legislation passed in the house, if government is facing no confidence motion, then in order to summon its MPs and order the MPs to vote in a certain directions, both ruling party as well as opposition parties will issue a 3-line whip, and any member of the house will not be able to deny this 3-line whip from their respective political parties, and if they deny it, if they do not follow it in letter and spirit, then their membership is liable to be cancelled. Okay, so this is how political parties can regulate the conduct of an MP by issuance of a direction called as a whip. Now let us understand what are the important changes that have been made in 2023. I told you 91st Amendment Act was introduced. Now it made 2 important changes. First is the deletion of the word split. In the original anti-defection law that was introduced from 52nd Amendment Act of 1985, it said that a split of 1/3 members of a party, if they merge into another party, then it would be a legitimate defection, and therefore it won't be disqualified as per the anti-defection law. Now this provision of split was misused many times, and therefore an amendment was necessary to remove this kind of an exception, and as a result the 91st Amendment Act was passed, which deleted this 1/3 reference from the 10th schedule and therefore mandated that any only kind of split that is permissible if it is done by 2/3 members who will then decide to merge with any other parties. So if the word comes split, you have to categorize it as incorrect, because the correct interpretation here is merger of at least 2/3 members of a party in a house with another party. That is only the one that is exempted now as per the 91st Amendment Act of the Constitution. And second changes that the 91st Amendment Act actually brought was that it limited the total amount of MPs that can get the status of a minister. So it stated that the total amount of ministers in a state government or in the central government shall not exceed 15% of the total strength of Lok Sabha or state legislative assembly. And in case if the state is small, then you need to have minimum of 12 ministers, including the CM. So these are the two important changes made by the 91st Amendment Act. Now let us understand, can judiciary actually intervene in the proceedings of anti-defection law? Can judiciary actually intervene in the decisions made by speaker in case he is discharging decisions for the anti-defection law? Let us understand it. Now, prima facie, if you read Article 122 of the Constitution, you will realize that the courts do not have the power to inquire into validity of the parliamentary proceedings, and same is the case with proceedings of the state legislature as per Article 212 also, that courts can't question these irregularities. So can court actually intervene? The answer is yes. Why? Because Supreme Court in many important cases have said that the decision of the speaker here to disqualify a member under 10th schedule of the Constitution is speaker using not his legislative power or legislative functions, but his functions as a tribunal, his functions as a judiciary. And therefore here the courts have the right to intervene. This matter first was clarified by the Supreme Court in the Quixote-Holland case of 1992, where the constitutional validity of 10th schedule was in question. Supreme Court stated, although the constitutional validity of 10th schedule, it is valid, however, it ruled that the speaker's decision, it will be subjected to judicial review on the grounds of mala fide intention, on the grounds of being perverse. Similarly, in Ravi S. Nayak case versus Union of India of 1994, here the conduct of MPs were in question. What if I've not formally resigned from the party? What if the party has removed me? So in that case, if the party removes an MP, then that MP won't be disqualified. For the MP to be removed, it has to give a voluntary resignation. Now let us suppose in a case, what if the party MP does not give a formal resignation but goes around and says bad things about the party, violates the directions of the party? Then also this conduct will be interpreted as a voluntary resignation from the membership of the party, and therefore his membership is liable to be disqualified under 10th schedule. This was clarified by the Supreme Court in Ravi S. Nayak versus Union of India case 1994. Similarly, in G. Vishwanathan versus Speaker of Tamil Nadu case of 1995, here the Supreme Court validated speaker's authority in anti-defection cases and stated that this decision can't be interfered with by the Supreme Court or any higher judiciary before it is made. Only after the speaker is done and dusted with the decision, then only the judiciary can review it. The judiciary can't prevent speakers from acting, or it can't prevent speakers from not disqualifying any MPs. And in 2020, Supreme Court also dealt with the time validity. If you can remember, I've told you that the 10th schedule does not impose a time limit on the presiding officer on when and how to decide on the matters of 10th schedule. And this is a very big loophole, because when the speakers or presiding officers want to be impartial and they do not have adequate resource to disqualify the member, so they prolong this decision. And Supreme Court actually directed, or it given advice, that ideally should be within 3 months of time when the presiding officer should take a decision as far as the decisions of anti-defection law is concerned. So these are the various interpretations done by the Supreme Court in order to operationalize, in order to refine, and in order to review the decisions made by the speaker. When the Supreme Court will intervene? After the decision has been made by the speaker, not before it, please remember. Okay. Now, before we solve two PYQs that have come in the exam, there is an important announcement. If you are really serious about 2027, 2028 or even 2029 UPSC attempts, you need to make sure of one thing. First of all, in order to reduce the wastage of time which can happen in case if you're preparing for this exam on your own, you can consider taking admissions in StudyIQ courses. Right now, if you take admission, this is a limited time offer that you're going to get 50% off and double validity of all courses. So suppose if you're going to provide a course with a validity of 30 months, that is 2.5 years, you're going to get it for 5 years, that is 60 months. So this is how it will work. These are the best rate possible to get admissions at these rates. Just make sure to use this code ATS Live. If you're going to use this code, you're going to get maximum discounts. That is possible on this platform. Now, there are two questions that I've picked up for our today's discussion. One is from 2014. Which one of the following schedules of the Constitution contains the provision regarding anti-defection? Very straightforward question. No need to answer. If you want to answer it, just let me know in the comment section. This one is a little better. It came also albeit recently in 2022 with reference to anti-defection law in India. Consider the following statements. Do let me know the correct answers of this two statements. Which of them are correct in the comment section? And what do you think about these defections? Should we make political defections, all the political defections outlawed? Do let me know in the comment section. Or do you think this merger provision is actually a good exemption? I want to take your opinion on this matter, and if you want to download the notes, you can go to this particular Telegram channel called as ATS Live, and while you're at it, please do not forget to subscribe to the channel as well. So this is all from my side. Please have a very happy weekend. We'll see each other again quite soon.